That's right, man. That's all right.
Good morning, Mr. Adams.
Morning, Judge Booley.
Good morning, Mr. Odinger.
Good morning, Judge.
Good morning, Ms. Duffy.
Good morning, Your Honor. I do just want to note that I'll have to jump off at 9:30 as I have a council meeting.
It's okay as far as I'm concerned.
Thank you.
Mr. Larsen, can you hear me?
I'm sorry, Your Honor. Who was that addressed to?
Mr. Larsen?
He's here. He's good morning, Your Honor. Kurt Bale, General Counsel for Mr. Larsen. He's on the line with me. He just got a new laptop. He was having some difficulty opening up the camera. There's an option to slide the camera off or on. He's having some difficulty trying to figure that out. So we are working on that as we speak, Your Honor.
Okay, Mr. Ball, thank you for that. Ms. Neal, can you hear me?
Morning.
Katie, are you there?
Yes, we are here, Your Honor. We can hear you.
All right.
Your Honor, your video doesn't seem to be working though.
It'll work once I turn it on. Details. Well, we had triple digits here on Saturday. How about you guys?
95 in Milwaukee.
Yeah, it was high 90s the last couple days.
So on Saturday, I had to drive through Ashland to go to Odina. I drove through Ashland. It was 96. Came back a couple hours later, and someone turned on the air conditioner because it was 66. That's called living next to Lake Superior. Mr. Auditor, do you get that kind of changes in Milwaukee?
We do, right by the lake we do.
Yeah.
And it protects us. So it's this time of year, it's good. It's cooler by the lake, but in the winter, it's not as great because we'll get some lake enhancement snow sometimes too.
Yeah, but that lake effect snow is enchanting at times.
Mm-hmm.
Okay, are we waiting for anyone?
Not from the defendant's perspective.
Is Leah going to be joining us, Andrew?
I don't believe she's going to be joining us this morning.
Okay.
Mr. Larson, have you worked out your technical difficulties?
Your Honor, Mr. Larsen can appear via audio. Is it okay if he does not appear via video?
For today's hearing, that'd be fine, but if and when we get to the trial, he will need to appear by video.
Understood, Your Honor, absolutely.
Right.
Okay, he should be available. He just needs to unmute himself.
If he announce himself once he's available, so I know that he's there, I'd appreciate that.
He is available. He's there, Your Honor.
Mr. Larsen, can you hear me?
He may need to leave the room and come back.
Lawrence, you need to check in. Just let the court know that you're there. I can't hear you. I can't hear you now.
As Ms. Nelson, maybe he needs to leave the room and come back.
Worst case scenario, I guess you could do it on your phone. Okay, he's waiting. He's waiting right now.
Mr. Larsen, I believe the connection.
We can't hear you. Is there another mute?
This is Andy. Just for purposes of expediency, I believe it's a dial-in number, so maybe Mr. Larsen could just dial in using his phone, just so he can listen in.
Mr. Larsen, can you hear me?
Check in now. Okay, there you go. There you go.
Can see you, can hear you.
We can see you, but we can't hear you. Is your volume turned up? Is there like a volume? Okay.
Can anybody hear me?
Yep, there you are.
Perfect.
You have to close.
So you're on there twice, you're going to shut off Williams.
There
Yeah,
you go.
I shut off my laptop.
Okay. Can you hear me all right?
I can hear you, yeah.
Yeah, I can hear you fine. Okay, are we prepared to begin? Read the case, please.
The case today is in the interest of the St. Croix Indians of Wisconsin versus Lawrence Larsen. Case number 20-CP-204. Presiding today is the Honorable Judge Stephen Cooley. Appearances for the record, Your Honor, are for the tribe, Andrew Adams III and Ashley Duffy. With the defendant, Lawrence Larsen, his attorneys, Andrew Odinger and Kurt Ball.
Okay, on behalf of the tribe, who's going to do the speaking today?
I'm sorry, Your Honor. What? You couldn't quite hear you.
On behalf of the tribe, who will be speaking for the tribe today?
I will, Your Honor. Attorney Adams.
Okay, on the behalf of Mr. Larsen, who will be doing the speaking today?
Your Honor, on behalf of Mr. Larsen, it will be me, Andy Ottinger.
Okay, thank you. Okay, it's my understanding today is time set for a summary judgment.
That's correct, Your Honor. That's my understanding as well.
Mr. Adams?
Yes, Your Honor. It's my understanding the court's going to take up the the defendant's motion for summary judgment.
Okay, before we start that, the question I have is, what do you guys agree to?
Your Honor, I think that there are, as it relates to summary judgment, I don't believe we've been able to reach an agreement as to what the specific items are that are in dispute, such that we would know what they are for trial. We have not, that is Attorney Adams and I have not conferred on whether or not the tribe will agree that certain claims need to be dismissed. I'm sure we could do so if the court orders it. There's a related item that's outstanding that I don't think we're here for today, which is a separate motion to compel that we filed. I raise that only because it's another item that perhaps Mr. Adams and I can confer on, but that, at least on behalf of Mr. Larsen, we absolutely need to make sure we address it at some point prior to finalizing the logistics for the trial, because we're asking for some very serious relief in that case. And there's some very important information we believe we need if we are to proceed to a trial. But those are separate issues, but I just want to make sure they're on everybody's radar as something we need to discuss at some point.
We'll address that particular matter before the day is over. Let's get back to the point at hand. You're telling me that you and Mr. Adams have not talked about this?
Your Honor, we have discussed summary judgment. Are you asking about summary judgment or about the motion to compel?
The summary judgment.
We have conferred regarding summary judgment. I don't want to speak for Mr. Adams, but I don't believe that the tribe agrees that we're entitled to the relief that we're seeking because the tribe filed an opposition brief. We have not spoken about the subject matter of the motion after Mr. Larsen filed his reply brief.
And if I may, Your Honor, maybe, and I'm not trying to be a stickler on definitions, but when Your Honor, when you say conferred, you mean have Attorney Ottinger and I met or spoke over the phone concerning the motion for summary judgment?
Well, look at what the summary judgment is you guys give me the fact that you agree on, and then from the fact that you guys agree on, I make a decision whether that's enough for me to make a decision. So when I ask you, what do you guys come to an agreement on? That's what I'm looking for.
Yeah, just from to be explicitly clear in terms of answering your question, Your Honor, outside of the pleadings that have been filed with the court, I have not conferred at all with the plaintiff's counsel concerning the motion for summary judgment. I believe that there's huge disagreements between the plaintiff and the defendant.
Mr.
I'm
Ottinger?
sorry, defendant's counsel. I haven't conferred with defendant's counsel outside of the pleadings that have been filed with the court.
Mr. Ottinger?
I think that's right, Your Honor. I do agree that there are disputes, but what we're putting forth in our motion before the court and what we're prepared to discuss today is that while the tribe does disagree or does not agree that certain facts are not in dispute, we believe it's quite clear that the tribe has not actually disputed them. That is, has not put forth evidence that shows there's a material issue of fact. And that is under the St. Croix rules of St. Croix rules of civil procedure. The tribe has to demonstrate that certain facts are in dispute, and it needs to do so with evidence. And our position that we can discuss in depth today is that other than counsel for the tribe saying that facts are in dispute, the tribe has not put forth evidence that outlines what the disputed facts are. So that's why we believe a trial is going to be unnecessary. We certainly wish and would hope that the tribe would acknowledge that they have not put forth those facts, but we can demonstrate that today. If the court believes that it would be constructive for Attorney Adams and I to discuss it further, and for me to again request that the tribe identify the facts supporting its statement that there are disputed facts, I'd be happy to do so. Attorney Adams and I disagree on a number of things, but we've worked together well. That is, we're happy to discuss things. But the fact of the matter is that after more than 1 year in this case, we still have not been presented evidence in the form of documents or testimony that show that the material facts in this case are in dispute. And that's why our position is going to be that a trial is not only unnecessary, it's prohibited under the rules because it says the court must grant summary judgment if there are not disputed material facts.
Let me see if I got this right. You're saying that the tribe needs to prove their case, and if they can't prove their case at this particular point in time, now I should dismiss this? Is that what you're telling me?
No, Your Honor, not quite close to that. But what I'm arguing is that under the rules of the applicable rules of procedure governing a summary judgment motion, which is specifically Tribal Court Code Section 310B, it says the court shall grant summary judgment if the pleadings and evidence show that there's no genuine issue as to any material fact, and we show that we are entitled to judgment as a matter of law. So what I'd submit the purpose of this hearing and this procedural mechanism is to figure out what exactly is it that we would need to have a trial about. Because the purpose of the trial is if there's any disputed facts, the fact finder, the judge, needs to decide who's telling the truth. So if one party is saying the light was red and the other party is saying the light was green, we need to have a trial on that because somebody's not telling the truth and we need to get to the bottom of that. And that's why we have the trial process. Here, in St. Croix Tribal Court and in most courts, there's this mechanism for summary judgment that says, if there aren't any facts, material facts in dispute, we don't need to have a trial because there's only legal issues. And we're not going to have a trial by surprise. So if one party has a reason to say, to argue that, or has evidence that one fact isn't true, they need to identify it and point to it. They can't wait to trial to do so. And what we've alleged in our moving papers, really getting down to brass tacks, and maybe Attorney Adams and I can discuss it right now, is that certain facts that are material, that are critical to the case, are not in dispute. Those facts are that Lawrence Larsen was never affiliated with gaming, and the tribe has never put forth any evidence to the contrary. So that's fact number one. Fact number two, that Lawrence Larsen and the work that he did on behalf of the tribe was for the tribe's economic development. And we put that before the court because we have evidence of that. We have testimony under oath from Mr. Larsen. We have St. Croix ordinances. We have press releases from the tribe. We have public documents from the tribe. We have resolutions from the tribe that say that the work being undertaken by Mr. Larsen, specifically the work that he did assisting with financing, assisting with CBD and industrial hemp, and assisting with efforts to retrofit the old fish hatchery, that those were for the tribe's economic development. And we're submitting that that's not in dispute. And throughout the 1 year that this case has been going on, the tribe has never put forth any evidence to the contrary. In fact, the people that we asked said, for example, Chairperson Lowe said she didn't know one way or the other. She didn't know anything about it. So those are critical facts. The third fact that we submit is not in dispute, and that we have not seen any evidence to the contrary, is that every time Mr. Larsen was paid, he was paid via payroll, he was paid through wires, he was paid through checks. Every payment that was ever provided to Mr. Larsen was authorized. And by that, we mean we have documentation, and the tribe has shown documentation, that it was always approved, signed off by the tribal leadership. So all the work that he did was signed off by the tribal leadership. And the reason that that's an important fact is because the other big claim in this case is that the tribe says he embezzled money or converted the money. Even though the tribe has never said that he didn't do the work, that the work wasn't good. In fact, the tribe never complained about the work that he performed. And so those, I think, relatively straightforward three facts are what this case hinges on. And if the tribe has any evidence to the contrary, we haven't seen it, and the tribe hasn't submitted it to the court, and has not submitted it to us in the discovery process. And because of that, we believe that because there's not a material issue of fact, that the court needs to enter judgment in our favor. If the court were to find there are disputes of fact, the court, we submit, would need to identify what those facts are, because that's what we would have the trial about. And that's what we would be requesting today, is if the court does not agree that the tribe failed to carry its burden, put forth and identify what the disputes of fact are, that the court should make findings as to what the facts in dispute are. So that was a long answer to succinctly answer, Your Honor. We don't believe the tribe needs to prove its whole case for the hearing today. But what the tribe needed to do and did not do, now that discovery is closed, now that this motion has been submitted, the tribe needed to identify what facts were in dispute. And in addition to identifying them, the tribe needs to put forth evidence as to why they're in dispute. And the tribe has not done so. All the tribe has done is say in its briefing and through argument that Attorney Adams believes there's disputed facts, but that's not good enough.
Mr. Adams?
Yes, Your Honor. Well, I mean, the long and the short of it, Your Honor, is that, I mean, of course, the defendant is going to make an argument that there's no material facts in dispute and that we haven't met our burden. But what the defendant fails to acknowledge to the court, Your Honor, is that the clear fact that if Mr. Larsen was never affiliated with any type of gaming activities at the tribe, then why was he receiving checks directly from the tribe's casino? We have shown that through documentary evidence that has been provided to the defendant through discovery, that Mr. Larsen received significant amount of money directly from the tribe's casino, and that is clearly a material fact that's in dispute, Your Honor, and it would be premature at this point for the court to make some type of inference related to that fact and its application to St. Croix law. I mean, the whole purpose of a trial is to get down to the brass tacks, as counsel for the defendant would say, and provide the court with the opportunity to hear testimony and to weigh those facts related to the laws that apply at the tribe. At this point, Your Honor, it would be the court should not be weighing this evidence without the benefits of a trial. We have provided, and I don't believe that the defendant could make any type of argument to counter this, but we have provided evidence regarding the payments that Mr. Larsen received. We produced accounting department copies of checks and disbursement forms, as well as wires and signed copies of those checks. We've done that, Your Honor. The tribe has provided redacted external bank account records and also internal general ledger reports to the defendant. Additionally, Your Honor, we provided an affidavit of Carrie Stafford, with our written response and explaining that if the court provides the opportunity or denies this motion and moves forward with the trial, that she can provide further details regarding those funds. We haven't hidden that fact from the defendant. And at his deposition under oath, Mr. Larsen acknowledged and agreed that the St. Croix casino logo appeared on checks that he received. I mean, he didn't, at no point, during that deposition did he state that he never walked into the casino or he never received any checks from the casino. So, I mean, Your Honor, it's not as plain and simple as the defendant is arguing. At Penny Till's deposition, she testified that she interacted with the defendant only at the casino itself, not at the tribe's governmental center, not at some economic development, location that the tribe owns and operates. And I mean, I think any reasonable person could take the inference that he knew that he was receiving funds from the casino based on the fact that the casino's logo, appeared on checks and that he was interacting with casino staff. And Your Honor, the tribe's gaming ordinance restricts, the use of revenue that's created, by the casino on its face. And so, Your Honor, there's a genuine question of fact regarding the permissibility of the payments to Mr. Larsen under tribal law. At his deposition, Mr. Larsen provided very vague recollections of what, he used the checks and wires for. And he provided very vague recollections of an alleged, verbal contract, whereby he agreed to receive $80,000 to $100,000 a year in salary. And I mean, based on those vague recollections, Your Honor, that's not, we make the argument that that's not enough for the court to grant a motion for summary judgment at this point. There is a clear question of fact, Your Honor, whether if the payments were permissible, did Mr. Larsen use them for appropriate purposes? Mr. Larsen received the tribe's money, and in some cases, not as an employment payment, but instead for quote unquote building supplies or quote unquote equipment. And yet he has no record of how those funds were actually used, or he hasn't shown through discovery, if they were for appropriate purposes and what the funds were used for. So, I mean, respectfully, Your Honor, I believe that there's a tremendous amount of material facts that are in dispute, and the purpose of the trial is to get to the bottom of those.
As I say, if you're contemplating granting the summary judgment, and every time you get to the point of saying, I'm ready to grant the summary judgment based on the technicalities that you put on the table, keep coming to the fact that there's some questions that I have that haven't been answered. And in that light, I'm going to make you guys go through with the trial. I'm going to deny your motion for a summary judgment. We're going to go through with the trial as scheduled. We have a pre-trial schedule next Monday. We're going to deal with the motion that we talked about earlier to dismiss. We're going to discuss that at that pre-trial. What time are we scheduled to start next Monday? 9 o'clock again?
Your Honor, that's correct. The pre-trial is next Monday morning.
We'll start out that day and we'll discuss the motion that you presented, the motion to dismiss. We'll discuss that first and then we'll go on into the pretrial if necessary. But right now I have questions that I want to answer.
Your Honor, for purposes of the, I'm sorry, Your Honor.
Excuse me.
For purposes of the trial and just.
Excuse me. Thank you. I just heard a reference, and I've read it in other places that Mr. Larsen received 6 digits as far as compensation. I want to know what he had to do. That's the question I have, and you guys are going to need to show that to me. And then if, while working as he earned that kind of money, responsibilities, rights, I want to know what that is too. If you guys come to an agreement on that, we can revisit this question. But if you can't come to an agreement about what that is, then we're definitely going to go through with the trial. But right now, where I'm looking at this, we're going to go through the trial. So again, we'll discuss the motion to dismiss that was presented to the court. We'll discuss that on Friday, or maybe next Monday at 9 o'clock. And then we'll go on to the pre-trial to discuss whatever other undecided issues need to be addressed at that particular point in time, if necessary. Are there any other questions?
Your Honor, just for to understand your order, are you asking that Attorney Adams and I discuss the what we've put forth concerning what Mr. Larsen did? The facts, the testimony that we believe is undisputed as to the work he did for economic development, that is contained in what we filed in our summary judgment motion in the form of his affidavit. So our belief is that that is before the court. Is there a particular part of it that the court wants more clarity on? Because that is all contained in the affidavit of Mr. Larsen, and we don't believe that it's disputed. Unless Attorney Adams can point us to where he's disputed it, I think that the only dispute from the tribe has been Attorney Adams saying it's disputed, but there's no testimony from the tribe that disputes that Mr. Larsen did the work that he, the economic development work that he performed. Just to be clear as well, we do not, it is undisputed that Mr. Larsen was paid the 6 figures. He was paid for the work that he did. So that is an issue that is not in dispute. We don't dispute that.
You have submitted something in writing. And when you submit something in writing, it's good. It's helpful. Give me something to base my discussion on, but I want to hear it. Again, right now, unless something changes, we're going to go to a trial. You're going to explain to me what you submitted in writing, and I'm going to want to hear it again. I have way too many questions here. And other than the big question I have, and I'm going to want answered for, is duties and responsibilities of the defendant. And then we'll go from there. As far as the attorneys getting together and discussing what they want to agree to or not agree to, that it's up to them. Right now, we're scheduled for a 4-day trial. That's going to be on the edge of summer. If you guys want to spend 4 days doing this and want to make that that long, that's up to you. But if you guys can come up with some facts that you want to agree to, put it on the table in a different form than what we already have, you can do that too. If you want to do whatever you can to shorten the process, to let the court know that that's what we can do. The court will consider if you both put it on mutually. But if you can't come to an agreement about something, then we'll process it through the trial. Any questions? All right.
Your Honor, no, that makes sense to the defendant. I understand we're going to deal with the motion to compel on Monday, as the court said, and the motion for sanctions and dismissal. What part of the relief we're seeking in that motion is our right to get some additional discovery if the trial is going to move forward, and it sounds like it does. I'm concerned that if the court does grant that relief, that we'd be unable to complete that discovery we're requesting in the week that follows. Specifically, the relief, one of the theories of relief we're requesting is we need an analysis done of email that was kept from the court, and I don't know how long that takes. And so while we're certainly ready, willing, and able to appear for the trial, we reserve our rights because we feel we've been improperly deprived of information that we need for the trial if we're going to go forward, and that we need to conduct a subsequent deposition of Ms. Lowe because we have determined that she misrepresented herself at her deposition. So we believe we have a right to get the information we need and to ask her about it. Mr. Larsen does have rights, and he needs to make sure he has the ability to mount a defense. And it is not, again, not disputed that certain information was not given by Ms. Lowe prior to her deposition. She and counsel later recanted and said, yes, it turns out she did have some information that is critical to this case. And so we need to make sure we can revisit it with her. That's a long way of saying I want to highlight that issue, that we're going to be asking for that as we have in our hearing next Monday. And as a result of that, having a trial a week later might not allow us to do that additional discovery. And perhaps it's something Attorney Adams and I can discuss as well to see if we can jointly come up with a suggested proposal. We have not discussed that.
Okay, here's what you're telling me. You did a deposition on Miss Lowe. And she provided you information that you came to believe because it's a deposition. And it came to light after the fact that she did not provide you with appropriate information, and that came to light after the deposition. Is that correct?
That's correct. That's
Have you
correct.
talked with Mr. Adams about that?
Yes, we have. And after the deposition, he did provide some documentation that should have been provided in advance. I believe the excuse given was that the tribal council did not previously ask Ms. Lowe to collect the information, and she later identified some of it.
So there's questions that you have right now for Ms. Lowe. Did you provide those questions to Mr. Adams after you received the information that she didn't provide you with everything that she had?
Yes, the additional questions, well, there's two parts. We believe we have a right to ask Ms. Lowe about the information that was given afterwards. And to be clear, the information concerns things she said about Mr. Larsen and concerns communications she had with the NIGC that led to the NIG starting its investigation. So we think that they're critical. So we want the ability to ask her about those emails, but also we do not believe, and we have reasons to believe, that she still has not provided all of the information. And we can demonstrate that. She's only provided a few emails. They provided, I think, 10 or 11 pages of new information. We know there's more. And the reason we know there's more is because we served a Freedom of Information Act request on the NIGC, and we've seen that there's additional information. So we need that information before we depose her again. And we believe we're entitled to our costs for doing so, but that's a separate issue.
Say that last part again.
We believe that we're entitled to our costs for having to do this a second time, but that's a second issue that we're seeking separate relief for. But first things first, we need the additional information.
Mr. Adams, you have a response?
So just to be clear, Your Honor, are you taking this issue up like this morning? Because what I had heard is that you were going to take up the defendant's motion to compel and to dismiss at the pretrial conference. I mean, the whole premise, Your Honor, of the position that the defendant is taking related to this motion for concerning the discovery sanctions is that the defendant believes that the only reason why this case is being brought is because the NIGC is making the tribe pursue this prosecution. And Your Honor, I would argue that that is just categorically, it doesn't matter why the tribe is bringing it. I mean, under Talman versus Friedman, Anselo, Lindbergh, Your Honor, Wisconsin courts have said that despite the tribe's evidence that establishes that the defendant received and accepted hundreds of thousands of dollars in payments for undocumented work that Mr. Larsen has provided no written explanation for what was conducted, the tribe's motivation for bringing this litigation has no bearing whatsoever on the claims related to the settlement agreement. So, Your Honor, it's the issue of the emails is far more complex than Your Honor, we in our pleadings that we provided to the court, we've shown that we've provided the defendant, I think it's close to like 50,000 emails. And so I guess I'm just kind of curious, are we dealing with this today, or are we going to deal with, this proposed or supposed or alleged discovery? Because I take the standpoint, Your Honor, that we have provided ample documentation to Mr. Larsen to mount a defense. And what it ultimately comes down to, Your Honor, is the tribe has been extremely forthcoming in providing evidence. But at the end of the day, Your Honor, Mr. Larsen has not provided, in the same respect, Mr. Larsen has not provided documentary evidence related to what the building supplies were for, what the quote unquote equipment was for, and what exactly he did, for the large amounts of money that he received from the tribe. And so, Your Honor, this is, I take the standpoint that this is a bait and switch to say that the tribe committed, major discovery infractions to warrant, throwing out the case. I respectfully argue, Your Honor, that is not the case. And what it ultimately comes down to is, can Mr. Larsen show that for the amount of money that he received from the tribe, was it for appropriate and legitimate purposes? That's the whole basis of the trial, Your Honor, is so that the court can hear from Mr. Larsen and from others, what happened. And Your Honor, to be quite honest, I don't know in terms of, I have not received any supplemental, interrogatory requests or anything like that from the defendant. And I leave it to the court, Your Honor. We have briefed this thing. The defendant filed his motion for, his motion to compel and for discovery sanctions. We filed a response. The defendant filed an answer or a reply, Your Honor. I don't believe, and Attorney Ottinger can correct me if he believes that I'm wrong, but I don't believe when it comes to the motion to compel and for discovery sanctions that we're going to come to agreement through a meet and confer, whether like he's right or I'm wrong. I think that the pleadings are in front of the court. If you order us, Your Honor, to discuss this further, I will fully comply with the court's wishes. Or if you want additional, I don't know if additional briefing is in order or what, Your Honor, but I guess I'm just kind of confused as to whether we're taking this up today or if this is going to be taken up at the pretrial conference.
All right, thank you. I allowed Mr. Ottinger to put that on the table. The thought that maybe you guys can come to an agreement today. You can't. We'll pick it up on Monday. You gave me an idea of the scope of the issue. Thank you for that. That'll help me be a little bit better prepared on Monday. And we will discuss that on Monday. Mr. Ottinger, you're indicating that you didn't get proper discovery. Mr. Ottinger indicated you provided the defense with 50,000 emails. We'll definitely have a discussion about that. So with that, we'll see you next Monday at 9 o'clock.
Thank you, Your Honor.
Thank you, Your Honor. We will, if we confer and have anything to report, we'll submit something jointly to the court.
That's for you guys to decide if you want to do that or not. But like I said, if you guys do come to agreement on anything, let me know, and I'll give it due consideration. And I say that, I mean that. If you guys come to an agreement on something, the court will give it definitely due consideration. Thank you. All right. All right. Court's adjourned.
Okay, thank you.
Thank you, Judge. Thanks, everybody.